Privacy impact assessment consultants versus data protection solicitors. Which one is better for GDPR and cross-border data flows? Most companies get this wrong. They think GDPR compliance is just about policies and privacy statements. The surprising truth is that managing cross-border data flows requires expert evaluation and ongoing legal oversight. Privacy impact assessment (PA) consultants specialize in identifying and mitigating privacy risks. They map data flows, assess risk levels, and provide actionable recommendations to comply with GDPR and other international frameworks. For instance, a multinational company transferring employee or customer data between the US and Asia can benefit from PAs to ensure lawful processing and minimize regulatory exposure. Data protection solicitors, in contrast, provide legal interpretation, represent companies in regulatory matters, and draft contracts or policies to ensure enforceability. They are critical when dealing with complex agreements, regulatory audits, or potential enforcement actions. However, relying solely on solicitors may leave gaps in operational risk assessment or day-to-day compliance monitoring. The ideal approach is complementary. PA consultants identify risks, propose process changes, and ensure practical compliance, while data protection solicitors validate legal standing, advise on cross-border contracts, and defend the organization if regulatory issues arise. By combining both, companies can proactively manage data flows, mitigate fines, and maintain trust with clients and regulators. The key takeaway is that GDPR compliance is both operational and legal. The surprising truth is that the most effective organizations leverage consultants for detailed assessments and solicitors for legal assurance, ensuring cross-border data is handled efficiently, legally, and with minimal risk.